Good morning, everybody. Thank you for attending today's webinar regarding the eviction moratorium. We have Dee Dee Richards with us today with Coldwell Banker and Ann Michelle Francis with the Eviction Service Center to discuss these topics and to give us more information to help us move forward as this eviction moratorium starts to come to an end. So Dee Dee, I'll kick it right over to you.
Thank you. Can you see my screen first of all?
Yes.
And can you see it change?
Yes.
Okay, great. Just wanted to make sure because we've had some technical difficulties this morning and got a little off course. So good morning, everybody. Thanks for joining us. I'm Dee Dee Richards, your trusted advisor for all things real estate. And today we are talking with Ann Michelle Francis of the Eviction Service Center. And this call is so appropriate because last year I had Ann Michelle on the same webinar with the chamber. And that was right when the eviction moratorium started and everyone was kind of freaking out and didn't know what to do. So now it's very appropriate that we have Ann Michelle back as the moratorium is ending. So here's my information. Dee Dee Richards, I'm a realtor in South County, top 2% of Coldwell Banker realtors nationwide. I cover all of Santa Clara County and into Watsonville, Monterey, kind of go where my clients take me. And I am a mom, a wife, an organic gardener, an enthusiastic wine consumer, especially since the pandemic hit. There's my contact information at the bottom. And here is Ann Michelle Francis's contact information. She, again, is a paralegal with the Eviction Service Center, and she's been with them since 2005. She's worked with all aspects of the unlawful detainer process and specializes in complicated matters, including but not limited to California statewide eviction moratorium, California COVID Tenant Protection Act of 2020. There's a lot of them. I'm not going to go through all of them, but she's really good. And she knows all about how to deal with tenants, helping landlords. She's held board positions as public relations and events chair for the National Association for Residential Property Managers and was awarded Affiliate of the Year by that organization in Santa Clara County 2 consecutive years in a row. And I will attest to this. She hosts the wildly successful private Facebook group for landlords called Handling Problem Tenants Like a Boss. So here you are, Ann Michelle Francis.
Yes, thank you. So my name's Ann Michelle and I work at the Eviction Service Center. My father is the attorney, Dan Paris, and I've worked with him for 16 years now. So I don't know how exactly that happened, but over the last year and a half, and especially through the eviction moratorium, I have been going live every single Thursday at 11 a.m. in my private Facebook group. It is for landlords only. You have to answer the 3 entry questions in order to get in. And then once you're in, you get these live updates every Thursday that you can also replay at any time. And they're amazingly informative. I don't know anyone else in the industry in California who's going live in front of their customers and their clients every single Thursday, but that is what I do. So if you are a landlord in California, although I specialize in Santa Clara County during the moratorium, then you'll want to tune in because I have so much information that I share every single week and it's always related on all of the questions that I get. Also visit our website, evictionservicecenter.com, download a free cheat sheet of how to navigate through the eviction moratorium. It's basically like in a nutshell of everything that I'm talking about today, but I'll go into more detail today with what I'm talking about. So am I starting the presentation now?
Yeah, let's go.
Okay, so professional note, this is no longer the environment to self-manage your properties or to dabble in property management. If you find yourself managing your own properties or saying, I dabble, this is not the time anymore. You need to refer out those properties to property managers who are continuing their education on an ongoing basis, who are attending my lives every single Thursday. Those are the most knowledgeable property managers in the industry. Anyone who doesn't know about the eviction moratorium or who is still serving 3-day notices is wrong, and you do not want them on your side. And if that is you, you do not want to be managing your properties on your own. You will be facing heavy fines now or in the future. So my advice is to hire a property manager who does not sell real estate, and the 2 of you can bounce off of each other and offer referrals. I also have a list of referrals that I can send you for property managers that I would be happy to share with you. So you can email me, it's am@evictionservicecenter.com, or you can post it in that private Facebook group once I admit you.
Perfect. Oop, let me go to the next one.
So the eviction moratorium in a nutshell. So an eviction moratorium means there are no evictions. How did the eviction moratorium come about? It came about because the state of California believed that if they prevented evictions, then it would reduce the spread of COVID. That is the initial reason that the moratorium began, reduce the spread of COVID. Well, the longer that they kept people in their houses and the longer there was lockdown, the less chances people had to be able to make money to pay their rent. So they extended it and extended it and extended it. So the eviction moratorium covers the time period of March 1, 2020 through September 30th, 2021. So there's a very real possibility that you may have a tenant in your property who has not paid you a dime since March last year, and they still don't need to pay you a dime until October 1st, 2021. And so that is where we're at in this eviction moratorium. There have been several amendments to the eviction moratorium and different things that have happened along the way, but I'll walk you through the most important information. So the moratorium ends on September 30th, 2021. After the moratorium ends, I am calling this the 7th and 8th trimesters of the eviction moratorium, and that will continue through March 31st. No one else says that. So if you actually use those words, no one will know what you're talking about. But if you're in my Facebook group, then you'll know, I know what you're talking about, because they're making it sound like the eviction moratorium is ending and that we'll just be in full swing evictions again. And that is absolutely not the case. It is going to be harder to evict once the moratorium ends than it is right now. So from October until March next year, it will be harder to evict your tenants. So I have some strategies and things you can do that I'll talk about at the end of the presentation in order to be able to prepare now. But I'm calling it the 7th and 8th trimesters because the state is trying to warm us up to, oh, the eviction moratorium is ending, and it's not. It's really just an extension of the moratorium.
That's crazy.
It is. And there are only, so right now, so back to that other slide, right now, there are only 4 reasons that you can issue the last slide.
I'm sorry. Let me go back up one. There we go. Is that the
right
right
now?
one?
Yes. So right now, things to know in terms of the eviction moratorium, there are only 4 reasons that you can give a 30 or 60-day notice. There are no more 3-day notices. So if you're serving a 3-day notice, do not do it. It means that you are being misinformed or you are outdated in your information. I'm being very, very blunt here because there are going to be fines associated with this if you have not already been fined. If you are using 3-day notices, hire somebody new or hire somebody to cover your properties. 15-day notices replace 3-day notices, and that is effective through September 30th. But don't worry, because after September 30th, we go back to the 3-day notice. The 3-day notice will not be the traditional 3-day notice. So do not use those forms that you've had sitting there for 20 years. And it will be a 3-day notice plus a 20-day notice. And I will talk about that later as well. Next slide. I'm actually, because you said that this is a 30-minute call versus a 60, I'm going to skip through this. So you can skip over the protected period. You can skip over the transition period. We can talk about the end of the eviction moratorium. So my 7th and 8th trimesters of the eviction moratorium is when we have the 3-day notices back again. So let me backtrack a little bit. During the eviction moratorium, they separated it into 2 time frames. One is the protected time period, and one is the transition time period. The protected time period was March 1st, 2020 through August 31st, 2020. If a tenant signed a declaration, then they didn't owe any rent for that time period at all. You could eventually sue them in small claims court for it, but small claims court still isn't open for that. So if somebody owed you rent during that and gave you a declaration, then there's nothing you can do. Second time period is called the transition time period. And it's from September 1st, 2020 through September 30th, 2021. That time period is that if any tenant owes rent during that period and they give you a signed declaration, then that signed declaration protects them for that time period and you cannot evict them. They also do not owe the rent until September 30th, 2021. At that time, September 30th, 2021, they will only owe you 25% of the rent that was due for each month prior. So if they paid in full for a couple of months, then they don't owe you for those months. But if any other months they paid less than 25%, then they need to pay the remaining balance of 25% by September 30th, 2021. If they don't, then October 1st, we can serve a 3-day notice for non-payment of rent. Again, this is not our standard 3-day notice. It is going to be a new notice. So make sure you get a new one. The new 3-day notice that will be issued then you can demand that 25% that was not paid to you. We believe you'll also be able to ask for the rent moving forward in just a standard 3-day notice as well. Again, we haven't gotten there to October yet. We haven't taken anything before a judge yet. So a lot of this is unknown and we're kind of guessing with what it means. But for any rent that's due during this transition time period, September to September, then you can do a 3-day notice. After you serve that 3-day notice, you'll have to wait 20 days before you can file your eviction. So it's a 3-day notice plus 20 days. So what is the reason for the wait? Well, it's actually very, very detailed and very lengthy what exactly you're waiting for. But in a nutshell, you cannot file an eviction until you have received proof or a decline letter from the rent relief program that has said that your tenant does not qualify for any funds in the state to help them repay any of that rent. So very important here is you have to receive a decline letter. So if you just get a letter that says pending, application pending, that doesn't count. That's not a decline letter. That means that you're waiting until you get an actual decline letter. It means they have to get information from the tenant. They have to get information from you. And also means that in order to even file an eviction, you need to apply for the rent relief program, even if your tenant doesn't qualify. You're going to need a decline letter that says that they don't qualify for it. So it's really, really important. If your tenant is behind now and has not given you a declaration, then you need to get a 15-day notice out right now. And if you haven't done that, it's just going to cause even more delays after October. So in the future, when the moratorium ends, you'll have to serve a 3-day notice. You have to wait 20 days before filing to see if the tenant has been declined or not, or else you'll have to wait until you get that decline letter from the rent relief program. And so that is whichever comes last is when you'll be able to start your eviction. So
and Michelle, what is a decline letter?
So it's when you apply for the rent relief program and the rent relief program comes back and says, this is you're not approved. Your tenant's not approved and we decline your application. For whatever reason. The problem is that most applications are pending for 4 and 5 months before they issue any letters. So decline the letters are not taking a week to issue. They're taking a long time. So I think that that's one of the additional delays that they're putting in there, that they're creating this buffer for. Okay, you have to wait 20 days or until you get this decline letter. And then they're just pushing out how long it's going to take to review all the applications and issue decline letters.
That was one of my questions for you, because we've heard about government assistance, the funds not really actually getting into the hands of tenants. So are you seeing that it's just taking the bureaucracy, the red tape is just taking so long, and the tenants aren't actually getting that relief in hand?
I'm seeing several things. So as of June 30th, which is when the eviction moratorium was supposed to end last, it was not in the hands of anybody. There was no rush to get it to anyone, and it had not been distributed at all. So I understood the moratorium would be extended simply because all these people we would be starting evictions on, and there was the money, but it wasn't being given out to anyone yet. So I saw the moratorium being extended for that purpose alone. So then it's been extended. So I am seeing that a lot of landlords are getting reimbursed. They're getting reimbursed more than they thought they'd get reimbursed. They're getting reimbursed for future rent, which is also a problem because I'm seeing landlords taking rent through November now, and now they want to evict their tenant because their tenants are breaking the rules. Well, you can't. You need to look at the fine print. You can't do an eviction until possibly 60 days after you receive the funding. But if they covered future rent, then that's probably 60 days after you've received that future rent too. So you need to look really closely. And if you do want to start an eviction for any reason, you need to send over that actual agreement that you signed with rent relief in addition to all your paperwork, because I need to look through that and see what you signed up for. And also the date of funding is really important as well. So those are some of the issues that I'm starting to see, is that tenants I'm seeing tenants breaking the rules, but then a lot more rent was covered. Owners tend to not know what's even being covered in some of these things. And the other biggest issue I'm seeing is that the people who are administering the program, these are untrained people. You have to figure these are probably people who were on unemployment, who needed a job, and they got them in real quick and said, okay, here are the requirements. They are giving legal advice. I 100% can tell you they're giving legal advice, and they're giving bad legal advice, and they're giving landlords bad information. So the landlords are coming to me and saying, oh, they said that I could just refund the 30 days if I'm going to start an eviction. I said, who is this person? No, you can't do no. And all of the things that this one person continually told me about, the administrator of the program, I was baffled. And the problem is that landlords come to me thinking that's the expert. Right. And that is not the expert. So
right.
you need
to be coming from the agency, right? It's coming from the government agency. So it must be right.
Exactly. So you have to be very careful about the information you're getting.
Okay, woo, this is good stuff.
Yeah. So what is the eviction moratorium? This is where I'm going to skip through also because this is where I talked about kind of the different time periods. I'm going to have you stop on the next slide because these are the 4 reasons you can issue a 30 and 60-day notice. So go back to the slide right before that. Yes, this one. You can issue a 30 or 60-day notice right now and through September 30th, and you'll want to reconsider that. Is it even worth it to serve a notice right now, or do you want to wait until the moratorium ends? Again, I can't predict if they're going to make any amendments or changes after October. I can only tell you what's happening right now. Right now, these are the reasons you can issue a 30 or 60-day notice, and these are the only reasons. Owner move-in, and the owner only means spouse, domestic partner, children, grandchildren, parents, or grandparents. So if you want to move back into your property, you can issue a termination notice. You also have to give 1 month of free rent. So it's called relocation assistance. You also have to give 1 month of free rent, and you can only use this option if you issued a notice of exemption from AB 1482, which is statewide just cause, prior to last year, which actually the date is August 1st, 2020. If you did not do that, if you do not know what that exemption is, then that's not an option for you. Next is if the property's in contract and the buyer intends to occupy it as their primary residence, then you would be able to issue a 30 or 60-day notice with 1 month relocation. Again, this is only if you issued that notice of exemption from AB 1482 prior to last year. If you didn't, that's not an option for you either. The most common option that I'm seeing is the withdrawal from the rental market. So that's where most people are saying, okay, I just want these people out, or they haven't paid me in a year. And obviously we can't say that would be retaliation if you're doing it because of rent. But if you just want to withdraw from the rental market, you don't want the property on the market anymore, then you have that option. But you need to be aware you're withdrawing it from a rental market for 2 to 3 years. What I am seeing people do is people withdrawing it from the rental market and then moving out of their homes, moving into this property, and then renting out their homes so that they can, so it's withdrawn and it's staying withdrawn for 2 to 3 years, but then they also get that non-paying tenant out rather than this endless thing. Now we're getting closer to the moratorium ending, which again, it'll still probably take longer to do evictions after the moratorium ends, but there are there's some, I guess, relief that owners are looking at here. So also with withdrawal from the rental market, if you choose to sell it after you get the tenant out, you can do that. Be aware, I don't believe you can do a 1031 exchange on it because now you're withdrawing it from the rental market. So 1031 exchange is going to be related to rental market property. This is no longer a rental property. The other thing to be aware of is that it needs to be off the market for the 2 to 3 year time period. And if you are selling it, you need to disclose that to the buyer because the buyer could get in trouble if they put it back on the rental market. So I get a lot of people saying, but I'm selling it to an investor. If the investor is going to sit on it for 2 to 3 years, then sell it. Otherwise, you can't use that option. And then on the next one,
really important. I wanted to touch on that for just a second because it can be a really smart strategy. I did this myself. We had a rental property that was rented for 7 years. It was my primary residence, rented it out after I moved. And then we wanted to move back into it for a few years to just, kind of get our properties together. And then after, I think it was 3 years, we sold it and we didn't have to pay the capital gains on it because it was then our primary residence. So talk to your CPA, your tax person, and see if that is a smart strategy for you. It possibly could be, and it is something that is legal. It's very popular to do. If you've held an income property for 10, 15 years, the capital gain on that, if you're not doing an exchange, is pretty severe. So if you want to potentially avoid capital gains and it fits into kind of your overall plan of how you want to move your assets around, then talk to your CPA. It could be a good strategy.
Excellent. And then the next slide, I have one more reason that was given to us, which most people should not be able to use. But so if there's substantial remodel to the property that's required as a result of city or county code violations. So if that came up, then you could also issue a notice, but really you don't, that's essentially a red tagged property and that's not where you want to go with that either. So you have options, most of them are not usable. So withdrawal from the rental market is what I'm seeing most often. So the rent relief program. So what is that? That is a program that's funded. There's federal funds, but it is issued and run by the state. There's 1.4 billion in federal funds that's been given to California, and they are now reimbursing landlords 100% of the rent. Before it was 80%, as long as the landlord waives the other 20%. Now they're giving 100% plus more. They're giving amounts that people don't even know what they are getting it for. The only caveat is that this is only for qualifying tenants. So what is a qualifying tenant? The tenant needs to prove that they've been impacted, and the tenant needs to make a certain amount of income. So if somebody is a high income tenant and just hasn't been paying you, actually high income tenants are different if you can prove it. But if somebody does not meet the threshold of this program, then you're not going to get the funding for it. So I'll talk about that in a minute. If you want to apply to it, it's housingiskey.com. This funds were distributed in 3 phases. It really doesn't matter right now because they kept on getting more and more money, and there's a lot of money out there for people to try and get as long as their tenant qualifies. So we can go on to the next slide here. The rent relief program. So what you can do, this is a recommended action from the state. You should apply as soon as possible at housingiskey.com. You should apply for households and back rent that are, and this will be required for you to do after October 1st. Right now, you don't have to apply for the rent relief program. Right now, you can just kick out your tenant if they don't return that signed declaration to you. If they do return it to you, then you'll want to apply to the rent relief program. If the resident applied for the program first, then you should cooperate. There is nothing that is going to benefit you to ignore the tenant's request for to try and apply for the funding. So definitely cooperate. Take the money if they pay it. Don't say no unless there's something that's so terrible, like your tenant is involved in criminal action and you don't want them there. Otherwise, take the money and just deal with an eviction later. But you will not be able to evict for a certain period of time after you receive the funding. So there are going to start being a lot of variables here that we'll have to start looking at. So make sure you have your contract. I'm also hearing people say, I didn't sign anything. Oh no, I promise you did. I promise you checked boxes and you signed, you just didn't sign anything on paper. Go get a copy of that and you're going to bring that to me. For recommended actions, you can email me. It's am@evictionservicecenter.com. I do charge a $100 consultation fee, and that is so we can hop on the call. I can look at all of your documentation while we're on the phone, and I can tell you how to move forward. Most of the time right now, there is no action moving forward. It's okay, here's where you're at, here's what you need to do, and you need to wait until this date, and then we'll see what can happen from then. Most of the time, an eviction is not what the next step is, but you're going to have satisfaction. You're going to be able to sleep at night if you know what's going on with your property. And that's what I hear most often is, I can't sleep at night. Okay, well, let me help you sleep at night because it's not as big of a deal as you think it is.
Right. $100. That is too cheap, Anne Michelle, and worth every penny.
Thank you. So rent relief program tenant will only qualify for the program if they can prove all 3 of these things: reduction of income, so they lost income. They have unstable housing, which a 15-day notice would help demonstrate that. And they make below 80% of the area median income. So area median income is actually pretty high in Santa Clara County. However, that means that somebody who's making area median income is not going to qualify for this program because you have to be making less. So if you have those original records from when they moved in that shows what their income is, that's going to help you give you a baseline of whether or not where they're at. If you do not have income records from your tenants when they moved in, that is an excellent indication you should hire a property manager, because everyone should have income information for their tenants before they move in, or else you do not give them a key to your property.
Absolutely, 100%.
So there are 3 scenarios with the rent relief program. Scenario 1 is the landlord applies, the tenant cooperates, and the tenant qualifies, and 100% of the funding is issued, and it's issued directly to the landlord. Scenario 2 is the tenant applies, the landlord does not cooperate. Even if the landlord does not cooperate, if the tenant applies and qualifies, then 25% of the funding is issued directly to the tenant. So the tenant is going to be given that money and they're told to give it to the landlord to pay, and that's so that they will not be evicted. That covers that 25% that's due by September 30th. So they're not going to get evicted and you'd have to go to small claims court for the rest of it. Scenario 3 is if the landlord applies, the tenant does not cooperate, so tenant ignores, or the tenant doesn't qualify, then the application is terminated. It ends, no one gets any money. So even if the landlord's doing everything in there to help the tenant get the funding, the application will be terminated if the tenant just ignores it.
Okay. There's always caveats, aren't there?
So the caveat to the rent relief program, I talked about some of them, is that the tenant needs to qualify for the funding by meeting certain income thresholds. That's the first. The second is that the tenant never had to prove they were impacted financially through this entire moratorium by just signing a declaration, not proving anything, and just handing it over. And then they also don't qualify. The owner still doesn't get anything. So even though it's 100% to landlords, if that tenant never proved anything and that tenant doesn't qualify, landlord is still out. So you're really banking on them suddenly paying you 25% of the rent due on September 30th. And if not, get ready for an eviction. Caveat 3 is we have no idea how long it will take to get the funding. People are getting it fast. People are getting it slow. People are getting approvals fast. People are getting decline letters fast. They're getting them slow. Some people it takes a week. Some people it takes 5 months. So there is nothing consistent about any of it. I would assume that landlords with tenants who are working proactively are going to get funding the fastest if that's possible. So I'm going to answer the main questions here, which are the main topics of the presentation. Question 1, what are the 3 reasons you can use to evict a tenant prior to September 30th, 2021? You can still evict for non-payment of rent if your tenant does not return a signed declaration to you. Remember that non-payment of rent notice is a 15-day notice, not a 3-day. Do not write it yourself. Do not find a form online. Hire a professional. You can hire me. You can go to evictionservicecenter.com. Number 2 is breach of contract. Tenants still have to follow the rules. If they're not following the rules, if they're breaking the rules, if they're smoking in common areas, if they're making too much noise, if they're threatening and endangering other people, we can get them out faster. It's typically a warning notice and a 3-day notice to quit the property, to move out. So we can still get them out with that. And remember, there are only 4 reasons you can issue the 30 and 60-day notices, but the primary one is withdrawal from the rental market.
Okay.
How can you prepare today for when the moratorium ends on the 30th? Today, I recommend you prepare and serve a 15-day notice right now. If you're not doing it, then I should do it for you, evictionservicecenter.com, and you can get my contact info to help me set that up for you. So I can set up a 15-day notice now. Now, once that's served your tenant, then you need to wait the 15 days, and it's 15 business days, not calendar days. You have to wait for the tenant to sign a declaration or not. That is really the golden ticket here. Are they going to sign it or are they going to ignore it? If they do not sign it, if they do not return it, if they ignore you, they don't pay, they don't move out, they don't sign a declaration, then you call me, we start the eviction immediately, and we're going to push it through. I'm quoting people, evictions are taking 2 to 3 months. In reality, right now, real time, they're taking about 5 weeks. So that's what you can look at in terms of a timeline, a 15-day notice, and then an eviction if your tenant does not return the signed declaration. If they do return a signed declaration, then they are protected for that entire time period. So you need to go to the rent relief program, housingiskey.com, and apply as soon as possible for that funding so that you can get a decline letter as soon as possible so you can start your eviction when it comes to October, instead of waiting until October, serving a 3-day, then applying to the rent relief program and seeing when they start to respond. At least right now it's October 30 or August 31st. You can start putting your paperwork in to start getting things in place. You can actually apply for the rent relief program now. It's just that you will have to cancel that application if you end up starting an eviction. So you would have about 2 to 3 weeks of having that application pending, hopefully getting the funding or not. But if you don't, then you wouldn't be able to, if you don't get the funding, then you would be able to cancel it so you could start your eviction. So really my emphasis here is if you really want to evict your tenant and you don't care about the money, you just want to get the tenant out, serve that 15-day notice now and hope they don't return the signed declaration. If you really do want the funding, apply now. Rent relief to the rent relief program, housingiskey.com.
Okay.
And will evictions resume as usual when the moratorium ends? No, because there's the 3-day plus the 20-day plus all of these other requirements and documentation and declarations and things that I have to do on my end that are insanely ridiculous and time consuming. And every single thing that they pass down to us takes me more time to set each one up. And I am one person figuring all this out, me and the attorney, as we go through and navigate through this and make sure that each of our cases are solid. And also, this is new. I prepare each lawsuit and then I send it to you to review and make sure it's accurate. In the past, I never had to do that. For 15 years, I didn't have to do that. Now, every single one, because I do not want any one error on any lawsuit that I'm submitting, because I do not want any delays once I submit it. So when the moratorium ends, evictions will not resume until usual, probably until April 2022, where I assume we'll be back on our regular timelines. But for now, we are still dealing with eviction moratorium, declarations, transition time periods, and all the craziness that California has thrown at us.
And as you said, things can still change after October 1st, right?
They can. I'm predicting the moratorium won't be extended. However, they can still amend AB 832, which is the most recent amendment to the COVID Tenant Protection Act.
And here's why we need Anne Michelle. There are a lot of fines.
Yes, the laws are confusing. Get legal advice. Stop doing it on your own. This is no longer the environment to do it on your own. Wait until all the moratorium, everything's over again, and then consider doing it on your own. But again, if you don't know what AB 1482 is, don't do it on your own. There are 3 different things I've told you throughout this presentation that if you are not familiar with, don't do them on your own. And one more thing I'm going to throw in there. If you have your own rental agreement, it's not California Apartment Association. It's not a California or Apartment Owners Association, and it's not California Association of Realtors form, then your rental agreement is going to be wrong too. Stop using forms, hire a property manager. Those are indications that you should not be managing your property anymore if you're still using old forms. Or my favorite, you cut and paste things from your favorite leases and make them your own. Don't do that either.
That's good.
So seek legal advice, hire a certified property manager who does not sell real estate to manage your properties. The fines have increased. I just got a message from somebody in my Facebook group saying that they're being fined $100,000 and they need help, but they're in San Francisco and we don't work in San Francisco. This is real. This is real and it's happening. There is free defense attorneys are paid for by your tax dollars. Tenants get free money. Tenants get free legal assistance. Landlords get 0.
Right.
So remember that.
Right. Oh, that's so scary.
And Michelle, I have a question that asked if you work in Kern County, Bakersfield.
I do not. I only, right now during the eviction moratorium, I'm working in Santa Clara County only. We used to serve 7 counties in the Bay Area. During the moratorium, we have chosen to only work in Santa Clara County.
Do you have a referral to Kern maybe?
I do not have, I don't work with eviction offices in other counties. It's pretty far away. Yeah, so come visit me in my Facebook group, Handling Problem Tenants Like a Boss, or you can type in facebook.com/group/problem-tenants and you can find me and you will see me live every Thursday talking about a hot industry topic that is going to save you money and hopefully you won't get sued.
So Lori, for that person in Kern County, they can reach out to me and I can work through my contacts to see who we know over there.
Great. That's great. I'm going to give them my email address and then I can get with you on that. Okay.
Perfect. Yeah. And Michelle, I was speaking with a client yesterday and they served an eviction notice to their tenant and they are putting the house on the market. And they said, you know, what if he doesn't move out when the notice is, you know, the time frame is done? What if he doesn't move out? Can they extend it? Does that have any legal ramifications?
My first question is I want to know more about the notice that was served. 9 out of 10 times it's not right. Actually, not even 9 out of 10 times. I think only once a notice has been correct, because I won't start them on a notice that someone else has done because they're usually just wrong. So I'm just preparing people in advance. I should be doing them for you because otherwise you're wasting time and money because our attorney is not going to represent something that we haven't initiated or done on our own. Assuming we did the notice for you, if the tenant doesn't leave after 60 days, you have to make sure, number one, that you don't take any rent past the 60 days or else you have invalidated the termination notice. So you're not taking rent. Then you start the eviction and then the eviction is taking, I'm quoting 2 to 3 months. But right now it's about 5 weeks. If the tenant needs more time, then it's up to you to grant them more time. If they're asking for things that are health related, such as they have cancer or they broke their foot or something big, then we usually, or they are disabled, then we usually recommend a 60-day extension, but only a one-time 60-day extension. After that, we don't recommend any additional extensions. However, they need to put it in writing and they need to request it. Everything needs to be in writing once you've issued a notice. If it's not in writing, then we wouldn't grant anything.
Absolutely. Can you, I don't know if this is part of your specialty as well. Can you touch on the issues for the tenants, for the renters that might be listening to this? What are the ramifications for them not paying? As you said, there is a lot of free advice out there for renters, not so much for landlords and property owners. But for people I know, I have clients who have properties where tenants haven't paid for over a year. What are the ramifications for those renters moving forward?
So the 25% of rent is what's due starting September 30th, 2021. So we can serve a notice, we can start evictions. However, there's still 75% of that that's not being paid. And that's going to be small claims court. So that's really the only thing that you can do right now. Small claims court, there is no limit anymore. There's no limit for COVID related damages. And that is in effect through 2025. So landlords can continue to take their tenants to court to small claims court to get a judgment. Caveat with that is that if a judge, it is within the law as part of the COVID Tenant Relief Act, that it is at the judge's discretion to determine if they want to reduce the judgment as based on whether or not the landlord was compliant and helpful with the tenants, with the tenant getting funding or not. So if the judge felt like the landlord did not apply to rent relief program or didn't use any funding or wasn't cooperative, then the judge can reduce the amount to whatever they want. So be careful on small claims. It's not a slam dunk either. I think one of the problems most people are having is that tenants, they took off, they left California. So they may have left high and dry, but at least they're out of the property. They left, and the landlord can't find them to even get a judgment or take it to small claims court. Honestly, I just count my blessings in that situation and be thankful that they're gone.
Exactly. Lori, do we have any other questions before we move on?
I don't see any other questions. If you have questions, just type them right there in the chat box and we'll get them asked for you and answered.
Yep. I'll go on to the next slide. We just have a couple more things to announce.
Okay.
So upcoming events, we're doing this every other Tuesday, is Real Estate with me, Dee Dee Richards. The following in 2 weeks is September 14th, always at 11 o'clock. We're going to be talking about financing options when purchasing a home. And I'm also going to be giving a real estate update, a market update for our local community, because it is shifting and changing. I'm sure you're seeing that. And it's kind of a little bit in flux right now. So that'll be good to get everybody updated on what's going on. And then the following Tuesday, September 28th, again at 11, my co-host will be Dan Newquist, and he's right here in Morgan Hill. He's going to be talking about the financial markets and how to keep your nest egg growing safely through the pandemic and beyond. So those will both be really good shows to catch. And then I have 2 new listings in case anybody's looking for anything in Morgan Hill and Gilroy. 9071 Wren Avenue in Gilroy is a beautiful 4-bedroom, 2.5 bath on a large lot with a 3-car garage. Not easy to find 3-car garages these days for under 1.2 million. It's close to shopping and it's listed at $849,999. It's a really great property. So give me a call if you're interested in that. And then I also just listed 300 Pebble Creek Court in Morgan Hill. It's a gorgeous townhome. The previous owners were a contractor and the wife was an HGTV fanatic. And you get that when you walk into the house. It is perfect. It's gorgeous. That is a 3-bedroom, 2.5 bath townhome in Creekside Village, which is, I think, one of the best townhome communities in South County, if not the best. And it is $885 list price. And here is my contact information if you need to reach out to me. And Lori, any other questions?
I do not see any.
No.
If you come up with some, folks, when you leave, just reach out to any one of us, Dee Dee or myself. My information is in the chat. It's Lori, Lori at morganhillchamber.org. I'm happy to get you connected with Ann Michelle or Dee Dee, whichever one you need. And we're happy to get you moving along with any of the questions you have.
Absolutely. Thank you. And thank you everyone for attending. This will be out on my Facebook page, probably Ann Michelle's as well, and then the chamber page. Yeah. So you'll always be able to find it. If you need any additional information, feel free to reach out to me. And thank you, Ann Michelle, so much. Wow. I think the only thing more confusing than California real estate contracts is California tenant landlord laws. And people definitely need a lot of professional help to navigate those waters. $100,000 fine is insane. And no one wants that. So yeah, definitely. Thank you so much for all of the wonderful information. And maybe in a couple months, we'll have you back again for another update.
Yeah.
Good, thanks.
That would be great. Ann Michelle and Dee Dee, thank you so much for taking your time today and working this webinar with us. It was a lot of very valuable, important information. And I hope everybody has a great rest of your day.
Thanks, everybody. Have a good one.
Bye-bye.
Bye.